Hi and welcome back to my channel. So today I will look at the criminal trial process in subordinate courts. I will use the criminal procedure code as my reference, but most of the things I will say I have seen in person while attending courts. So it's really important. I thought it would be helpful to document this or have it, as part of my channel, because court process is highly kind of intimately hidden away and unless you attend court, it's really hard to decipher the process from just reading the criminal procedure code. So I will start with simply plea taking. So where the accused has been charged, the police drafts the charge and it is sent to the office of the prosecution, public prosecution, for approval. And once approved, the charge is kind of registered or filed in court, and the accused is who are mostly like apprehended or arrested. They are brought to court for plea taking. So the criminal procedure code mentions plea taking just from, I think, section 207, somewhere there. I don't have my code at the moment, but it's somewhere like section 200, between section 200 and, you know, like 208 is on plea of not guilty, then 210 is on acquittal, 211 is on defense, and 207 is the procedure for pleading guilty. So it's just around those sections. So in the case where an accused is in court to plead, the first thing that happens normally is the court clerk or the court reads the charge out loudly to the accused. And let's say if he has a count, maybe two counts, one of causing grievous harm contrary to some section of the penal code, and another is let's say being found without an ID or being of mature age and not registered as an ID holder. So let's say those two counts are presented and read out to the accused. He is in a language he understands, so mostly is in Kiswahili if the person does not understand English. And yeah, so for his comprehension, it is read out in that language which he understands, and then he gets a chance after each count has been read out to whether to say ni kweli au skweli, like whether to say guilty or not guilty. So in whatever language you can find some accused people say si kweli ama ni uongo, hiyo sikubali, such terms. But although the negative terms will all fall under the plea of not guilty. So if the accused is read count one, he says not guilty, he will also uh, uh, he will also hear about count two. The charge will be read, and he will also be given a chance to plead. So if there are several or many counts, he the accused person gets a chance to hear what he's been charged with in each count, and he's given a chance to plead for each count, whether guilty or not guilty. So where the accused pleads guilty, that is a very short process. If he pleads guilty, normally, let me see if I can remember offhand. If he pleads guilty, yeah, today I think there was such a case. It's like very easy. The process is once he pleads guilty, the magistrate will record the plea of guilty, okay, and he will say, let me just say, geez, I can't believe he will. Yeah. Once the court clerk finishes to read and the honorable or his honor plea records a plea of not guilty, the magistrate directs the ODPP, who will then, that is the public prosecutor, who will then read out the particulars of the charge. And that, I think, is in line with the Criminal Procedure Code, where it talks about uh, that once an accused person or a suspect pleads guilty, the particulars of the charge are read out to him in a language he understands, and this is normally, as I've seen it, is done by the prosecutor. So the particulars of the charge, which will indicate the time, the date, what, where, and how, and when, all of them will be read out to the accused, and he will be given a chance uh, to say whether those facts or particulars are true. Okay. If he says it is true, so the court will the court or the magistrate will say he is convicted on his own plea of guilty. Okay, the court has decided that he is convicted on his own plea of guilty, and the ODPP will kind of tell the magistrate there is no previous record. So he or she will say, no previous record, Your Honor. This means that this accused person is a first offender. Like he's being put through the system for the first time. So there's no previous record, in which case the magistrate will turn to the accused person who has pleaded guilty and ask him if he has any mitigation, if he wants to, like, if he wants the court to be lenient, kama anataka kujitetea, in which case most of the accused persons will beg the court, this is my first time, I have done this offense. Like there was this person who stole ngunda. Ngunda is this sun-dried fish that is popular in the coast, worth like 2,000 shillings. So in his mitigation, he told the magistrate that he was hungry. He had no money to buy any food, so he stole the ng'onda in hopes that he could buy something to feed himself and the family. So the court normally considers whatever the accused person says before they give out, like, they give out whatever decision they have made, whether it's imprisonment or a fine. So they will say, in consideration of his mitigation, so of the fact that hunger or starvation pushed you to commit this, to steal, or in the case where an accused person says, oh, I have no parents, I am a father of like 4 children, they all depend on me, the breadwinner, and you know, like, please have mercy or be lenient in consideration of those facts. So normally the court then says, in consideration of the mitigation and the fact that there is no previous record, normally the magistrate will proceed to say his decision, which might be either a fine or imprisonment, or sometimes in some cases, uh, where this person, like this guy who stole because he was hungry, the court said that it has considered that he was hungry, and he just simply forgave. The magistrate forgave and warned the accused, who then said, okay, thank you. And the magistrate said the stolen fish would be returned to the back to the complainant, because he hadn't yet sold any of it. So it was returned, and uh, he was warned that if he ever committed any offense and would come back to the court, uh, the the court would not be so merciful the next time around. So you find such scenarios, yeah. I think for petty offenses, or I don't know whether it's being lucky, but sometimes you find that you get pardoned, or the court will say that a probation officer should file a probation report, and the magistrate will give a date when uh, that probation report will be considered before he enters judgment. That is mostly for first offenders, people who do not have any previous record. Yeah, so, and the things normally, for example, if it was a case of maybe stealing, petty stealing, like a few thousands or a few hundred shillings worth of, and the magistrate or the court will order for those things to be returned to the complainant. Yeah, so that is when this person or accused pleads guilty. Okay, the process is very much simplified, because there's no need for opening a case, there's no need for the trial, for hearing or for trial, and all that back and forth. There's no need for witnesses, because the accused is convicted on his own plea of guilty, and the process can be done right there and then, and the accused will know whether he has to pay a fine or he has to serve time right there and then. Yeah, so it's a very time saving process and quite simplified. Another thing I think I kind of came across is, I think the disadvantage would be if you plead guilty, no appeal is allowed. Like, you can't appeal the case, but I'm not sure about that. Okay, I think so. It's somewhere, or heard someone say that. Okay. Um, Now, what happens in the case where the accused person pleads not guilty? So I think this is, I mentioned section 207 of the 208 of not guilty. If the accused person uh, hears about what is being charged, mashtaka yake, let's say if it's several counts or just one charge, if he hears it, what happens is he pleads not guilty or not true, he doesn't admit the truth of the charge, which the magistrate will announce that he has recorded a plea of not guilty for that particular count or that particular charge, in which case the ODPP normally now will start recollecting or identifying or the documents he or she has. That is, he will tell the court, Your Honor, I have a charge sheet, I have all the contents of the police file, or most of them. Like, I have the charge sheet, I have the investigation diary, I have the incident report, I have statements of how many witnesses. Like, the ODPP will mention how many witness statements, or the statement of how many witnesses he has or he wishes to produce. So if it's 4 witness statement, he will say, I have statements of 4 witnesses. If there's any letter, he will say, I have a letter from any kind of person, or that is involved in that complaint. If he has a P3 form, if in the case of charges relating to assault, uh, uh, or causing grievous harm, normally those, if there's been an injury and bleeding, normally uh, the or the ODPP will have a P3 form as part of the documents, or as part of his bundle. So he will say, when I have a P3 form, I have treatment notes. He'll say things like that. I have photos, in case he has any photographs as evidence he wishes to produce. He will say, Your Honor, I have evidence. I have 4 photographs, and I have a certificate to ascertain those photographs. It's called like a certificate of prints, which will show that it's just something, I think, a requirement from the Evidence Act, requiring those photos to be certified, and the person or institute or office which does this is called the Scene of Crime Office. They normally do the certification of photographs to be produced as evidence in court. So he will say, Your Honor, I have photographs, 4 photographs, and I have a certificate of prints. He will say, I have, what else I'm thinking? I have exhibits, a list of exhibits or an inventory showing those things that were collected as evidence. For example, in a case of assault, or in a case of grievous harm, what was used to cause that harm. If it's a knife, then the ODPP will say, I have a list of exhibits, or I have, what do you call, I have an inventory, okay, which is like a list of those items which which are to be produced in as evidence, okay. So after the ODPP has identified the stakabadhi, or the documents he or she has for the prosecution case, the most immediate thing the prosecutor does is to hand over copies of those mentioned documents to the accused person, and to obtain his or her signature. And that signature, normally the accused person signs somewhere. I think on the on the inside of the cover of the file, of the case file, he will sign to the list of the documents. He will sign against them or below them, something like that, just to ascertain that the accused person has received copies of the documents. Okay. After that, just a minute here. I am trying to recollect. I want to say them in order, because how else can you say these things? It's a process, so it's step by step. Uh-huh. Mm, just a minute, please. Yeah, so yeah, so normally the second process is okay. Yeah, so the second after the accused has signed, I remember, like barely, the court will proceed to set a hearing date, but before that, it will give bond or cash bail to the accused if the prosecutor has not like raised any application or suggestion of denying bond. Like for example, there's a case of rape, and the prosecutor straight out during plea taking, when the accused pleaded not guilty, the prosecutor announced her intention not her intention to apply to deny the accused bond for obvious reasons, because if the alleged rapist is given a chance to go back into the society, uh, and not be held in custody, what will happen is likely he's either going to interfere with witnesses, and maybe threaten the complainant into silence and or into withdrawing the case or into something, he's going to do something, or likely he's going to run away. So that is that case of rape. So in those serious cases, the prosecutor during plea taking will announce her intention to apply to deny bond, which application, mind you, will be made in writing and filed to the court, and there will be like a mention date or a ruling date set to determine that particular application, whether it is approved that the bond is denied or it is uh, rejected, in which case the bond is allowed. So the magistrate will determine bond or cash bail. Bond, in which case, for example, in the case of causing grievous bodily harm, we see a bond like of 100,000, sometimes with one surety or without surety of the same value, or it can be a cash bail of 200,000, something like that. So with it depends on the seriousness of the charge, whether the charge is for petty offenses, for example, like traffic offenses, driving a motorcycle, piki, or boda without license, would normally uh, uh, those people normally plead guilty anyway, and they're either given a fine, like for example, for driving without license, normally will attract a fine of Kenya shillings 2,000 shillings, or an imprisonment term of 2 months, and for not wearing a helmet, for example, like 500 shillings, or an imprisonment, let's say, of 1 month, something like that. So I think there is like guidelines on bond and bail, cash bail, in which case yeah, it will explain for those who are interested to know how the court decides on bond, how much or how much cash bail to give the accused. I think the details will be there. So, yeah. So I think I don't know if I left anything. I don't know if I left anything. Um, Let me just see whether I forgot anything. Yeah, so I forgot a very important thing. So according to section 208 of the Criminal Procedure Code, once the accused pleads not guilty, one of the most critical things that happen is the court will record a plea of not guilty and will notify the accused of three ways in which he can exercise or defend himself. He can say one of the ways is he will tell the clerk will explain to the accused that he can give his statement or his statement of defense under oath, like being sworn on oath, in which case his witnesses, if he has any, will be examined, will be cross-examined by the ODPP. Or another way is he proceeds to give an unsworn statement, in which case he will just remain in the dock and just give his statement and not proceed to the witness box. So he will remain in the dock where he's standing and he will just give his statement, in which case I think the witnesses will not be cross-examined, something like that. And in another way is, I think, to remain silent. I think I think if I got that right or not, someone can just correct me. So yeah, and then the court proceeds to set a hearing date. It will announce that um, the hearing will be, let's say for example, on 10th May 2023, and the people will, both the sides, DPP and the accused, will be present on that day. And normally, of course, the trial process starts with the examination in chief of the complainant and all prosecution witnesses, including the investigation officer, any police, any other witnesses that are critical to the prosecution case. And it's important to note that it is during the examination in chief, okay, where the prosecutor will produce the evidence, like I told you, where in a case of causing grievous harm, the weapon used, a knife, panga, something, the prosecutor will use the examination in chief stage of examining the complainant or the IO or something, and mostly the IO in this case, because they normally are quite involved with the investigations and collection of the exhibits or the evidence, the real evidence, panga or something, and the prosecutor will identify and produce those documents through that investigation officer or that complainant, and he will say, he or she as the prosecutor will ask the IO, is this the photo that you wish to produce? He says yes. So the ODPP will say to the magistrate, Your Honor, we wish to produce photograph 1, 2, 3, and 4 as exhibit A, B, C, and D, and the certificate of print as as excuse me, as exhibit 2, something like that. So it's really important when you see the process unfolding in person, you will understand the techniques that or the points, the critical points at which evidence starts coming out and being produced, and you will see how examination in chief is very important, yeah, how examination in chief is very very important on the side of the state as it tries to prove its case beyond a reasonable doubt, because that is the stage at which production of exhibits and identification of exhibits happens, production of evidence and identification of evidence happens during that stage. Uh, yeah, so I think that's it. I don't know if I missed anything. Yeah, if I missed anything. Yeah, so okay, I don't know where I have gone wrong or mixed up things. Yeah, so and then a point, there is this example of withdrawing of a case. So the complainant can withdraw the case anytime before a final order is given. So, in a case where the complainant perhaps forgives or no longer wishes to pursue this case, they will come to court, and what happens is the complainant will be sworn. Okay, uh, the complainant will be sworn in. They will say who they are, their names, they will say where they live, they will say what they do, and the magistrate or the court will ask or just confirm that the complainant is willing, as they have talked to the accused, what they have agreed, to forgive and withdraw the case. And yeah, he will confirm with a yes, or like yes mostly, because that is like withdrawal. So, and then the magistrates will like ask like if there was any loss, or if they agreed on how to be compensated. Have they agreed on anything? They will say. If it's just complete forgiveness, even including the any loss is forgiven, no need. If it's a case maybe of kupigana or something, afre or something, kama wamekubaliana, like if it's not afre, if it's just assault, like the the complainant wishes to withdraw the case. So after those questions, and after the court has let the complainant know that once he has withdrawn that case, he cannot bring it back to court, okay, for a second time. And if he understands that, then the court will proceed to withdraw the case under section 204 of the Criminal Procedure Code. Yeah, so that's it. The withdrawal is also very simple process. Another process I think I've seen is for bond or surety, where the mini or surety comes forth, and they produce maybe a title deed or something, to show, or a logbook of the value of the bond that was given. So what happens is they will go to court, and they will they will be sworn in just like normal. They will be sworn on oath, sorry, not sworn in. And they will just say their ID number, their full names, where they live, and their relationship with the accused person for whom they are guaranteeing, or they are covering for the bond. Yeah, so that's it. They will go through that process. Their details will be recorded by the court, and the DPP is doing all the questioning in this bond taking thing. And the DPP will make sure that the person understands his responsibilities as the mini, to make sure that the accused presents himself to court in every hearing, and if he fails to come, it is upon the mini to come to court and explain why the accused is not in court, and where the accused disappears, it is the DPP makes sure the mini understands that the mini will be the one who will be arrested. Okay, And also another thing the DPP confirms during bond taking is that if and when the accused commits any other offense during that time he is out on bond, the bond will be forfeited or it will be taken by the court. In case of a title deed, the court will sell that house or shamba and claim that bond. Okay, so that is that. I don't think I've forgotten anything so far. So where the case has been withdrawn, the court or magistrate will note or will announce that the cash bail or the cash bail is returned, it should be returned to the accused. Okay, and he will record that the case has been withdrawn under section 204 of the Criminal Procedure Code. Like I said, the Criminal Procedure Code is where all this step-by-step process comes from. But when you read the code and rely on just those sections, it is not, I don't know for you, but for me, it wasn't enough to get the picture until I saw it. I saw it happen. Okay, that is how I was able to put together the sections of the Criminal Procedure Code and things started making sense because the language that's being used in the Criminal Procedure Code itself is quite discouraging, and sometimes you can feel like you are rereading the same section several times and you doze off and or your attention gets disrupted because you feel like I'm not getting the picture, like the legalese and the use of some kind of brain coma inducing language, I would say, or terms. Sometimes you can find yourself rereading, like you know what they're trying to say, but they're beating around the bush or they're like using like they're trying not to make you understand, and the point is quite simple. Like the point can be communicated in a single 5 words sentence, but there's a whole paragraph, and I don't know, kizungu, like mingi, like it just takes you somewhere else. So it's best see this to see this face to face. Uh, what else did I forget? Yeah, so apparently, when you go through a cause list for the matters in that court, before that court on that specific day, before that specific magistrate, you will notice that it's like categorized. We have mentions, mingi mingi, like you can even find 15, 10 mentions. Then you have hearing, perhaps a ruling, and then a case that is for defense hearing, and a case for just hearing, of prosecution case maybe, and a judgment. So that cause list normally guides you when you go to court. It's better to have your own cause list because it will guide you. You will understand what's going on. And then there's this part that is not normally included in a cause list because it's called plea taking. That's like what I explained, section 207 and 08 of the CPC. That is, you know why they are not indicated? Because mostly those those most of those pleas are fresh complaints and they come in daily. Trust me, the police are busy. Like, there's hardly a day passes without a plea. And that is like a fresh charge sheet is brought to the office of the DPP a few minutes before they go to court, and then the charge sheet is read out. So sometimes on a busy day, you'll find that there are so many pleas and none of them are reflected. Don't panic on the cause list. Just listen and note that they are pleas, and they can be few or they can be as many as even 10, depending on how much crime was committed on that particular day or on the eve of that particular day. That is, yeah. So um apparently mentions are like, they're like dates. You know how you go on a quick date and you just like have coffee and then unapotea like that. So mentions, apparently they want, how I've understood, they are normally, for example, they are normally tackled first. Ziko huko mwanzo mwanzo on the cause list, and the court tackles them. They are read out. For example, if an accused person is in custody, pending the hearing of their case, every 2 weeks, every after 2 weeks, there'll be a mention for that case, so that the status of the accused person in custody can be ascertained, whether he is, the way I understood, whether he has escaped or is still in custody. Because you could be working on a case and trying to build a case, kumbe mtu asha abscond, like mtu asha escape from prison, from custody. So it's best that mention can also, if normally the prisoners are brought to court, and if they have any complaint or any request, maybe they want to access treatment services in a hospital, maybe they are sick or they have any grievance, or like any kind of thing they wish to tell the court normally during those missions will address that. Alafu hearings, of course, ni when the prosecution is saying to the court, I am ready, Your Honor, I have 3 witnesses and they are present here, they are ready, we can proceed and start the prosecution case, in which case normally those are the ones that take a long time, because it begins with the chief examination in chief, and kuna hiyo production of evidence and identification of exhibit, kisha kuna na hiyo cross examination, re-examination. So sometimes it can take very long. um, uh, what happens is, if a hearing doesn't take long, is a situation where the prosecution says, Your Honor, I'm not ready. I'm not ready. Unfortunately, I'm not ready because I could not avail or bring the witnesses to court. I request for summons to produce them. I request, Your Honor, to issue summons so that the witnesses can be compelled to come before the court, in which case the magistrate will issue the summons, will proceed to issue the summons or give a direction to the court to issue summons for those witnesses, and they'll be compelled to come. Sometimes the prosecution will say, I'm not ready, we request for adjournment, that is a later date, and for any reason. It can be, for example, the investigation officer has gone on leave and cannot testify. It can be that the complainant is not present in court, so we request for adjournment. Maybe ameshikika, ameenda hospitali, amesafiri, it can be like that. So that is what I have noted. And then there is judgment. Normally it's just like maybe in a day you can have one judgment, and this part is a bit kind of lengthy because the court will try in Kiswahili to read out the issues for determination, what cases he has used to arrive at his decision, and he will either say in this case the court has found the accused guilty, or because the evidence was not the evidence was contradictory or was inconsistent, and therefore we cannot prove this, or the prosecution could not prove this beyond a reasonable doubt, in which case I acquit the accused. Okay, so it can go either way, but the lengthy process is that reading out of that judgment, because an answer from the charge, the facts, particulars of the charge on this particular day at this place, uh, during this time you did this and this, alafu ana read out tena in Kiswahili, mostly because most of the people don't understand in English. So the judgment he tries, and you can see he's struggling with the words and kind of the transition from English to Kiswahili, but you get the point in the end. So he goes and goes, and where he needs where the magistrate has any or says them in English, the court clerk is already there to translate to the accused, because the accused must understand the content of the judgment and how the decision has been arrived at. So it's the court clerk will be ready to translate. So as he speaks, the court clerk says in Kiswahili, interpret, and that's how it is done. So whether the court finally arrives at a decision and says the evidence was not sufficient to prove beyond a reasonable doubt on this reason, or in light of the above, the court does not find the accused guilty, in which case he is acquitted for count 1, or he is acquitted for count 2, or for both. Where he is found guilty, he will say the court, based on the above evidence, the court finds the accused guilty, and then he will set a date to give the sentence, something like that. So, and for a ruling, I have seen that, for example, in the case where there's an application by the prosecution to deny bond, there will be a ruling on the cause list, subtopic ruling, and that case is to hear that application, what the court has decided. And sometimes, from my limited understanding, if I'm wrong, correct me, a ruling can mean also where the case decides the accused person has a case to answer and puts him on his defense. So that can also be, I think, from what I've seen. So, what else am I missing out? So cause list. I had a cause list. Let me just see. Yeah. So so I think I have seen. Sometimes you can find a subtopic on the course list, or the matter on the course list being defense hearing. So that is very clear. It's just for listening to the defense, to the accused as he gives his defense, and if he has any witnesses as he examines them. Okay, to show cause. Yeah. Also, there is one time I saw subtopic on a course list, but I'm yet to be present for a pre-trial conference. So I don't know even what to say on that. But once I have seen it take place, perhaps I can be best in a better position to tell you guys. So there was this ruling, for example, I'm just giving samples. Ruling Republic versus Banaheri Famau. This I think was a case about defilement, if I'm not wrong, and the ruling was the subtopic on the cause list of the matter was a ruling, and this matter came up for a ruling, and simply the court said, I have found that he has a case to answer considering the evidence of the prosecution. Okay, so he will proceed and set the date for defense hearing. He will give the date, he will double check if the date is convenient for the lawyer of the accused or the defense lawyer. And if he says is 8th May, okay, yeah, or your honor, unfortunately, it's not convenient. Can we please have 10th of May? Then his honor will look at the diary, see if it's convenient for him. Anyway, so I've realized something. It's like an interaction, and there's no like dictatorship. All these hearing dates, dates of hearing, defense hearing or hearing, normally you'll find the prosecution, the defense lawyer, the court normally agree on a date, because if it's not convenient for one party, you know what will happen. There'll be adjournment, there'll be this. So there's no dictatorship. Even the magistrate, like, wants to know if it's convenient, if the date he's proposing is convenient, and he's open to changing it to a later date if it's not convenient for the defense lawyer or for the, you know. So it's like a cooperative interaction. No one is dictating this or that. And once you see the whole process unfolding, you'll be actually very inspired by the justice system or the trial process, and how there's no tyranny by any party. Okay, it's all a matter of cooperation or working together. Also, one thing I found, an example of a judgment I found, there's this case that came up for judgment on the cause list, Republic versus Mohammed Bunu Bakari, 2 counts of trafficking drugs, one of trafficking, one of trafficking, one of, I think, escaping custody or escaping arrest or something like that, an alternative charge of possession of drugs. So you will find that sometimes the police can have this very well planned out charge sheet and alternative charges and this, and sometimes the judgments will, the evidence produced will, if it is inconsistent, if there's any alteration in the charge sheet as to time, if time is of essence, or if time is a matter in issue in that case, then you will see that, or you will note that the magistrate will point out these discrepancies one after another, or the inconsistencies in the prosecution case and the evidence they've produced and the witness testimonies. And he will use, that's why I think the hardest working person in a court during a trial is the judge or the magistrate, because they cannot at any point in time lose concentration. They cannot stop listening in to everything and recording it simultaneously. So, if because when they're giving judgment, everything, no matter how nuanced or how tiny or insignificant it might seem to me and you or ordinary people, you know, those things can change the course of the judgment. Those things can influence the magistrate or the judge in making his decision and in arriving at his judgment, because he will note everything said, and whether the prosecution witness statements are inconsistent. Maybe PW1 said this regarding the time of offense, what happened, the time of attack, and PW2 or PW3 said a different time. So you will note when the magistrate reads out the judgment, he will be noting those inconsistencies in the story, because this testimony or testifying is a narrative, and it needs to make sense. It needs to have a beginning and an end. There's like a theory there you are trying to prove. You are trying to prove, and you have a story well planned, step by step. But if that story at any point breaks apart or breaks off, and there's no explanation for that disconnection or disconnect, what happens is the magistrate will note those points of disconnect or inconsistencies, and he will use them to arrive at his judgment, in which case it will be most uh, favorable for the accused person. Because remember, the burden of proving, I made a video sometime back, like last year I think, on the burden of proof in criminal cases, and I said that the standard for criminal cases is higher and more strict than the one in civil cases. The prosecution or the state has to prove beyond a reasonable doubt. So, in any case where there's a disconnect in the narrative of the prosecution witness stories or evidence, that disconnect is enough to instill doubt. And where a doubt has surfaced, the magistrate will use or will point to that inconsistency and will say this has defeated, or this has uh, affected proving beyond a reasonable doubt, and for that reason I acquit the accused on count one of transporting or trafficking, because there was no transport. Okay, the element for trafficking is to prove movement, transport. There was movement from one place to another, and where the story or narrative is breaking or is inconsistent as to that, then you can imagine what happens. The magistrate will point to that aspect of or discrepancy in the story, and he will say, because of this inconsistency, the the element of movement or transporting of drugs has not been proved beyond a reasonable doubt, in which case I acquit the accused on the count of trafficking. But you see, the police are also smart. They have an alternative charge. So where they acquit on the count of trafficking, the alternative charge will hold, because the alternative is possession of drugs. So the magistrate in this case said he upheld the alternative charge of possession, but the charge of trafficking did not hold water because of inconsistencies in the narrative by the prosecution witnesses. Whew. So, when you listen to judgments being read out in court, you will understand that the magistrate paid very keen attention to everything which was said, including things you dozed off on, things you kind of thought were insignificant. The accused is just saying so many stories, is acting smart, cross examining and confusing the IO, but you never know what the magistrate is writing because they are always busy writing everything. Okay, so yeah, I think with that I'll stop here. And yeah, this whole process is quite intriguing, and if you find any interest in criminal law, I think the best thing to do is to attend court, criminal courts. Just go there and just see this whole process unfold live, just be there because there's so much you can learn, yeah, from seeing than just from reading, you know. So thank you so much. I hope this helps someone. um Thank you, and I'll see you next time. Bye bye. And my mouse is misbehaving, trying to end the stream.